Counsel, you want to place your appearances on the record, beginning with plaintiff?
Good morning, Your Honor. Discussing on behalf of Hertz.
And good morning, Your Honor. James Gilbert here on behalf of myself, acting as trustee for the Marion Sherman estate.
All right, and we had this case had been initially pre-tried back in June of last year, and we did an administrative stay for 6 months for counsel to seek guidance from probate court as to possible lapsed beneficiaries of the trust. By stipulation, that administrative stay was adjourned a couple months until today. So, Mr. Kukuski, as plaintiff's attorney, what's our status for them?
Well, Your Honor, I have not received a response or any other communications from Mr. Gilbert. I know he was going to be looking into that, as you said, probate matter and whether there is an action. We talked about possible joiner as well, with possibly the state, but I'm not actually sure where the status is.
Before this courtroom session even gets underway, you can already feel that this is not your typical routine hearing. What starts as a procedural trust dispute quickly turns into a layered legal puzzle involving missing heirs, probate complications, and a trustee navigating unfamiliar legal territory. And just when you think things might stay technical and uneventful, the courtroom shifts into an entirely different case involving a self-represented litigant taking on a city government over transparency laws. Stick around, because this session evolves from quiet legal uncertainty into a fascinating breakdown of rights, responsibilities, and courtroom strategy. The real question is, who truly understands the system better here?
Mr. Gilbert.
Okay, so Mr. Gilbert, what's our status here of seeking any, as the trustee, seeking any guidance from probate court as to lapsed beneficiaries?
Your Honor, I did prepare a probate case and file. I have to be quite honest, it was the first time I've ever done anything of this nature, and I think it was one of the first ones of this nature that probate court had seen, and also they've been very helpful. Right now, we're in the process of publishing in Minnesota and also locally for the 2 non-existent heirs. And also, I believe our hearing is scheduled for the end of April for determination.
Okay. Yeah, it's an unusual situation, and I think, as I've expressed before, I don't want to reach any determinations here in this case until we are able to ascertain if there are, it appears that there's some lapsed beneficiaries of the trust, and I would want to feel confident that we've provided notice to any successors that we might be required to provide notice to. So would it make sense to continue this stay then into the month of May to give you a chance to find that out from the probate court?
I would appreciate that, Your Honor, because like I said, hopefully we'll have a determination at the end of April, and then they'll tell us how we can proceed.
I would have no objection, Your Honor. This is a very interesting matter, new to me as well. So,
okay. Well, let's. I'll continue the case on an administrative stay for the results of a probate court filing, and we'll set it for a status conference on Monday, May 18 at 9:30 a.m. And the Zoom appearances are fine, or in person is fine, whatever you guys prefer. But
very good, Your Honor.
All right. Anything further from the plaintiff today?
No, Your Honor. Thank you.
Anything further from defense, Mr. Gilbert?
No, Your Honor. Thank you very much.
Okay. Have a good day. Third Circuit Court for the County of Sheboygan, and advice to the parties that we do provide public access both in the courtroom and also online, as I think you got a notice on your Zoom screen. We're here for a pretrial scheduling conference in the matter of Canal v. City of Sheboygan. It's filed 25-9174CZ. And Mr. Canal, good morning. You're representing yourself in this matter, is that correct?
Yes, good morning, Your Honor.
All right. And Ms. Belisle, you want to put your appearance on the record, please?
Yes, I'm Stacy Belisle. I'm representing the defendant.
Okay. This is looks like an action filed with several counts under the Freedom of Information Act and the Open Meetings Act. There's been a complaint and then an answer filed, a supplemental pleading filed that was responded to. Mr. Canal, are you satisfied with the pleadings, or are you seeking to amend them in any way?
I'm satisfied with the pleadings, Your Honor.
Ms. Belial, for the defense?
Yes, we are satisfied with the pleadings at this time.
Okay, we'll indicate that any amendments may not be filed without getting leave of the court by way of a motion. Is this a case that's subject to initial disclosures under the court rules, Ms. Belial? Do you know? Freedom of Information Act cases?
I believe so.
Okay. Have initial disclosures been filed by the parties?
I do not believe so.
Okay. All right. So, Mr. Canal, a civil action does require in Michigan something called initial disclosures, where you lay out in a little bit more, and there's a court rule about that you can look up. It lays out in a little more detail the factual support for the different claims. I know your complaint does have a lot of that, that you can cut and paste into those disclosures, but also a list of witnesses for each factual allegation, and the defense does the same thing. The theory is that, or the idea is that then both sides at the beginning stage of the litigation have a full account of the position and the factual basis for the position of the other side. So that can maybe help them focus their efforts in litigating the case. So that's usually done, it's required to be done right with the filing of the complaint. Looks like neither side has filed it. I'll give you both 21 days in which to file the initial disclosures. Mr. Canal, how long do you think you need to conduct formal discovery, like sending any requests for admissions or interrogatories, things of that nature?
Well, Your Honor, the original issue I'm having is getting any information from the city, so I don't know how to go about continuing to do that because I've already started trying. That's why I'm today. So.
You were breaking up a little bit. I didn't catch every word of that. But you said you were having a hard time getting some information. Are you still with us there? It looks like you froze up.
May I intervene, Your Honor? I think I know what he's saying.
Okay.
He continued. If this is what Mr. Cannell is trying to say, he's been filing additional FOIA requests with the city to obtain documentation and information, but that would be improper. Now that he has filed a lawsuit, he also has a companion 1983 federal claim in federal court. And so any FOIA requests that he's filing now seeking information about either of the lawsuits, there would be an applicable exemption to FOIA, to provision of that information under FOIA. So I think discovery at this point obviously is the way for him to go in terms of obtaining information now that the lawsuits have been filed. So if he's having issues obtaining information from the city, it's on that basis.
All right. Well, I mean, I'm not going to express any opinion today about whether ongoing FOIA requests are going to be proper for him or not. I'm not going to tell a citizen to not file FOIA requests. But Mr. Cannell, the court rules, if you're going to represent yourself, which is absolutely your right, then it's sort of your obligation to follow the court procedures. They are laid out in the Michigan court rules. There is a website, michiganlegalhelp.org. We have a self-help center here in the courthouse in the law library that does have a remote navigator, a real person, not AI bot, that you can communicate with. So you can use those resources. They're free of charge to you. Discovery is a formal process to gain information during the litigation of a case, where you can submit a list of questions that the defense attorneys have to give to the defense, and the defendants have to answer them. You can take a deposition if you want to do that. If you want to subpoena records, you can do that. However, because you're not an attorney, any subpoena that you wish to file, you have to first get permission from the court so that I would sign the subpoena. A subpoena signed by a non-attorney is invalid. So there's ways that you can go about demanding and requesting information in a formal way during the litigation of a case. So what I'll do is I'll afford both sides 120 days to conduct that discovery. And I'll give both sides 60 days in which to file witness lists that comply with MCR 2.401. And Ms. Belial, this doesn't seem like a case that's appropriate for any ADR or mediation. Would you agree?
I agree.
Okay. All right. So, Mr. Cannell, some cases we forward to private mediation to see if a mediator can help the parties resolve the disputes, because this is really a citizen suing a government for a Freedom of Information Act and Open Meetings Act violations. That doesn't really seem proper. So unless you think otherwise, I'm not inclined to refer you both to try to mediate your dispute. Would you agree?
Yes, Your Honor.
Okay. And there was a jury demand filed and a reliance on that jury demand. What would be the estimated length of the trial, Mr. Cannell, in your judgment, if it didn't get resolved by some motion or settlement along the way? If we did go to a jury trial, how many days do you think you need to present witnesses in your case?
I'm sure just less than a day, Your Honor.
Ms. Belial, how long do you think you'd anticipate?
Just because we have this companion case, and I'm not sure, I'm not working on that particularly. I'm just working on this particular case, and there may be crossover. At the longest, I would say just in case 3 days potentially.
Okay. All right, so what happens next, Mr. Cannell, is you and the defense can conduct discovery. If anybody needs some assistance with that, they can file motions with the court. If either side thinks that the facts are such that they're just entitled to judgment, they can file what's called a motion for summary disposition. And there's court rules about that you can review. At the end of discovery process, we'll come back for what's called a final pretrial conference, and that's to determine whether the case is resolved, whether there's any motions that need to be heard, or whether we're ready to schedule the case for trial. So let's see, about 4 months out is July. So I would have you come back on July 20th at 9 a.m. for a final pretrial. And I would allow Zoom appearances for that final pretrial as well. Of course, folks are welcome to be present in the courtroom anytime they wish as well. Okay, Mr. Cannell, for purposes of scheduling conference today, is there anything else that you need the court to do?
Yes, Your Honor. I had one question, and maybe I'll find this out as I'm going along, but I made repeated good faith efforts to resolve this issue without court intervention, and the city manager has put out at a open public meeting to all of city leadership not to communicate with me. Now that I'm in discovery, how do I go about obtaining this information if the city manager himself has openly put a gag order on the
Yeah, well, Mr. Cannell, sorry, you glitched out for a second. Are you with us here to hear my answer?
leadership? Oh my God.
Cannell, so I did hear the gist of your question. How are you supposed to gain information if the city manager's told the city not to communicate with you? Well, discovery, you would conduct discovery by sending the request to the defendant's attorney. It's not proper for you to directly communicate with a party with whom you're suing about the lawsuit. So when people have an attorney, then you have to communicate with the attorney. So that's how that works. So you send like a list of, you'll see in the court rules, there's something called interrogatories, which is where you get to ask questions. Or there's requests for the production of documents. There's requests for them to admit certain facts. If you prepare those things and serve them and file them under the court rules, then the defense attorney has a deadline to make sure that they work with the defense to submit responses to those or to file objections to those. but it's all done through the attorney, okay?
Thank you, Your Honor.
Any other questions today, Mr. Cannell?
No, Your Honor. Thank you for the court's time.
All right, anything further from the defense, Ms. Blau?
No, thank you, Your Honor.
Okay, thank you both. You have a good day.
Thank you very much.
Thank you, Your Honor.
All right, good morning, Mr. Lambert. Are you here on the Floral Legacy case?
Yes, Your Honor, I believe so.
Okay, and this was scheduled for a final pretrial today. It's filed 25-9139CB.
Your Honor,
We didn't have
forgive me.
anybody
I
appear
believe I
and
informed you
counsel,
incorrectly. I'm here on Sunrise.
oh, okay, you're here on Sunrise. Okay. All right, well, let me place you in. So you're here for the road commission then?
Nope.
Who are you here representing?
Sunrise
Oh.
Resort Association.
Oh, okay, you're with outside legal counsel. Okay,
Yes, Your Honor.
okay, very good. All right, let me place you in a waiting room till we get the other side there. Here for arraignment on a bench warrant in the case of People of the State of Michigan versus Marshall Harley. It's filed 26-7141FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, White County Prosecutor. Liz Elliott on behalf of Marshall Harley, who sits at council table to my right.
Okay, and I know he has retained counsel. Has retained counsel been made aware of the proceeding today then?
Yes, Your Honor, his office actually called me. He was unavailable, so I stepped in for him.
Okay, very good. And I know this was a recent bind over, so it looks like we haven't even arraigned Mr. Harley on the underlying charge that's set for March 17th at 1 p.m. We'll leave that date and time as scheduled. But Mr. Harley, it's alleged that you're in contempt of court for violating the conditions of your bond, in that it's alleged that you were in possession of methamphetamine on September 2nd, 2025, and that you were in possession of Suboxone on September 11th, 2025. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt. You have the right to the assistance of your lawyer at any such hearing to present evidence in your own defense and to cross-examine any of the evidence presented against you. If you are found to be in contempt, I could jail you for up to 93 days or fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond. Mr. Harley, do you understand the rights that you have and the maximum penalties for the contempt?
I believe I do.
Okay. And Ms. Elliott, to know how he wishes to proceed?
Not guilty, Your Honor.
Okay, we'll enter a plea of not guilty as to the contempt. And we'll schedule it for a status conference on the pending contempt for the same date and time as the arraignment on March 17th at 1 p.m. Do you know, has he been, are there any charges that are filed based on these allegations?
Yes, Your Honor, and he just waived over on that, so that arraignment should be scheduled soon as well.
Okay. All right. And on the possession of meth and the Suboxone?
Yes.
Okay, because when I was looking at the bind over packet, it looked like he had prescriptions for Suboxone around the same time period. Okay, and bond has been set in the methamphetamine case. Is he posted in that case?
Yes.
Okay. All right. Any thoughts as to release on this contempt matter, Ms. Goodrich?
Your Honor, because of the timeline, this was in September of 2025, and he's under bond under the new case that just got waived over. I guess it would make sense to issue a bond for him to be released on this and continue monitoring the bond line and have them all scheduled together.
Okay. Any thoughts on that, Ms. Elliott?
Well, Your Honor, he lost his housing as a result of a fire in his apartment building. He's in the middle of moving to a new apartment right now. Aside from these allegations, he's not had any trouble on bond, so we'd be asking for him to have a PR bond and be released so he can continue.
Okay, he had posted, it looks like a $5,000 10%. What I'll do is I'm going to reinstate that bond. But then I guess, and I don't know what conditions he may have in the methamphetamine case, but just the only case that's in front of me as I reviewed this is that he's pulled over last summer for a car that he bought, but hadn't yet switched over or insured. And there's a single Schedule 4 pill in his pocket. And then he gives the officers a bottle that he got from a doctor with 7 more pills in it. And they can't track down a prescription for it, but that's not always obtained. Doctors sometimes give directly without like a prescription through a pharmacy. So I don't even know whether this case, I know there was a waiver of the prelim. I'm really concerned about whether we're making a mountain out of a molehill here. And I guess I want to hear from both parties about whether on this case, he should be subjected to drug testing as he has been for 6 months for a pill in his pocket. Yes, Rich.
Oh, Your Honor, yeah, with the pending charges being controlled substance related, I would ask that he continue to be monitored, especially in light of the court's knowledge that methamphetamine was found on him at a later date, that there's a substance abuse issue here that needs to be monitored for public safety reasons.
All right, Ms. Elliott.
Well, I think that there's allegations that there's a substance abuse issue. I don't think those have been proven. I think that Mr. Harley was very forthright when he was pulled over by police. He's pulled over for a plate violation, and all of a sudden they're searching his pockets. Doesn't make a lot of sense to me. And then he willingly gives over this controlled substance, which led to further investigation, which led to the new charges. I think there's some question whether or not any of the drugs were even Mr. Harley's. And so I think any kind of drug testing at this point would be inappropriate.
Okay, well, the only case in front of me today is this case for possession of modafinil, a Schedule 4 substance. So in this case, I'm going to reinstate his bond, but I'm going to amend it to just a standard bond. No special conditions in this case. So the only bond conditions in this case, Mr. Harley, are that you not break the law and that you show up for court and you don't leave the state without permission. That's it.
Yeah.
Now, I don't know what conditions you have in the other case. You have to comply with those unless and until there's an appropriate motion in front of me and maybe grounds to amend that. But in this case, we're going to reinstate the bond and get you out today, standard conditions. And we'll see you on March 17th at 1 p.m. with your lawyer.
This courtroom session wraps up with a powerful reminder of how nuanced the legal system can be. Across multiple cases, we saw everything from procedural delays in trust litigation to a self-represented plaintiff navigating complex civil rules, and finally, a criminal matter where the judge took a notably balanced approach. In the contempt case, the judge carefully weighed the allegations against the actual evidence and raised a critical concern. Are we overreacting to a relatively minor issue? That decision to reinstate bond with minimal conditions shows a commitment to fairness rather than assumption. Overall, this hearing highlights how judges must constantly balance procedure, fairness, and practical judgment, all in real time. Now we want to hear from you. Do you think the judge handled these situations correctly? Or would you have ruled differently in any of these moments?